Yes, sir.
Are you pleading true and correct to this voluntarily and because it is true as it is alleged?
Yes.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can now be revoked and you can be sentenced up to the full range of punishment, which is up to 10 years in prison. Okay.
And I don't know that answer.
And then I just have Joseph Ledet or Ledet.
That's the same thing with him as well. Sir.
Those are reviews.
Yes, sir.
All right. You are Mr. Gilbert Marlowe,
Yes, sir.
and you are here with your attorney,
Yes, sir.
Mr. Johnson, the state's attorney. I think what we have here is a motion to revoke probation in the older case, 18-29833, and a 26 CR 392, a new case indicted on March 18th, operating a motor vehicle in a public place while intoxicated, a third-degree felony because of prior DWI convictions. The defendant was on probation for DWI, and it looks like this new indictment is represented as allegation 1.
Yes, sir.
In the motion to revoke probation, among other things. He's got 6 violations alleged, but we'll probably be working just off 1.
Well, yes, sir. But
It's all that's necessary.
Let me say this in terms of
What are we doing?
probation fees, they're paid up. I
That's
know it
fine.
doesn't make a difference,
That's
but I want to let that know.
Okay.
Let you know.
Well, that's not an issue, is it, with the state?
No.
No, sir.
Okay. So is that what we're going to do? He's going to enter a plea in this motion to revoke probation on the allegation, which is represented in the new indictment, and he's going to be pleading guilty to the
Yes,
new
sir.
indictment and going to run everything concurrent.
Yes, sir.
What's our plan?
4 years TDC.
4 years TDC in both cases.
Yes, sir.
To run concurrently, right?
Yes, sir.
All right, that's your understanding, sir.
Yes, sir.
All right. So what are you going to do when you get out about this happening again? What are we going to do to prevent it?
I'll get more help, counseling, and
Are you an alcoholic?
I'm an alcoholic.
Are you?
But due to stress, there's a lot of stress was going on in my life at that time. So son,
All right.
and stuff.
There's one thing.
Yeah, I feel like I'm.
I'm not going to talk to you like your dad or something,
Yeah.
but welcome to planet Earth.
Yeah, I'm here.
We all have stress.
Yes, sir.
All of us, every one of us.
Yes, sir.
Sit here and see how relaxing it is. It's like a clenched fist, but that's what we do. We manage it and deal with it and move forward as best we can.
Yes, sir.
But you got to recognize when you're in stress, you've got 2 ways to go: the right way or the wrong way. And the wrong way has
Yeah,
responsibilities
I chose
that you pay for.
Yeah, that's why I'm here. I chose the wrong way.
Well, fix it.
Yeah, I'm gonna fix it.
Okay, good.
I'm gonna fix
And
it.
you can always start today. All right, let's go. 18-29833, a motion to revoke probation. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
Mr. Hubert, raise your right hand. Do you solemnly swear or affirm that any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this motion states, and this was filed on February 4th of this year, it states that in this criminal district court of Jefferson County, Texas, on June 17th, 2019, you were sentenced to 10 years in prison, and that was suspended. You were placed on regular probation for the third-degree felony of operating a motor vehicle in a public place while intoxicated. We call that driving while intoxicated, but we know that the elements of the crime don't include the word driving. It's operating a motor vehicle while intoxicated. Is all of that true and correct?
Yes.
And allegation number 1 is represented by this indictment 26 CR 392. In summary, allegation 1 states that you committed the offense of driving while intoxicated, third, or operating a motor vehicle while intoxicated, actually, but it's the crime is entitled driving while intoxicated, a third degree felony, because you had two or more prior DWI convictions at the time, and you committed this offense on or about December 11th of last year, 2025 in Jefferson County, Texas, that is a violation of condition 1 of your probation order. And condition 1 states you shall commit no offense against the laws of this state or any of the state or the United States, which this is a violation of Texas law. Is this allegation true and correct as it is alleged in this motion to revoke probation?
Yes, sir.
Are you pleading true and correct to this voluntarily and because it is true as it is alleged?
Yes.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can now be revoked and you can be sentenced up to the full range of punishment, which is up to 10 years in prison. Knowing that, do you insist on pleading true today?
Yes.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. God bless you. Now, an agreement has been reached between the parties. We only needed to really do this agreement portion. Since it's a motion to revoke probation, an agreement's been reached where you would. I'm going to replace your 4 with the Arabic 4.
Yes, sir.
That we're used to. You know what happens is you're writing fast, and on this pad, it's you think you got problems. You know, I'm left-handed, so I put my hand on this, and look what I've done. Look what I do. I have to put this thing because the way I write as left-handers, if I didn't put this thing on top of it, it smudges it and it begins to write things. Well, I know what I feel your pain.
I have trouble writing period, Judge.
I've known you for a long time, Tim. I know that. In fact, the whole town knows that. We all know that. The whole community of law, we know. But we love you. That's what's so great about it.
I had trouble in law school.
Let me tell you, I miss your dad.
Yes, sir. Yes, sir.
Hardly a time goes by.
Judge, one day I'm bring his notes from college up here and let you take a look at them.
Yeah, I like that.
Yeah. They were meticulous.
I'm not surprised.
But
he was fabulous guy.
But the bad thing about it, he was meticulous, but he was always late. So he called secretaries up.
Well, I think he was probably busy on other things all the time.
Well,
that's the way I understood it. He wasn't late because he wasn't fashionable that way. I think it was because he got wrapped up in things, and then he'd go, "Oh, look at the time." Of course, he had that buddy of his that got him into some trouble. Elmo Wilder, those guys.
Yeah, well, his son's doing really well.
Yeah, that is right.
You notice that?
Yeah. But both of them were premier lawyers and very smart people. Very smart. Both of them were very smart people.
Yeah,
I was a young lawyer, and they were very kind to me as a young lawyer.
We going on the Wayback Machine. I remember being on your dad's television show.
Yeah, I was out.
And I still have my cowboy boots on.
Oh, did you?
At the end of his television show, he would say, "Stump your boots and clap your hands."
Well, everybody watched that show.
Yeah.
Anything can happen on live television, by the way, in those days with kids. Surprised that they didn't lose their license sometimes because things would be pop out of kids' mouths, and it was live television, and some of it was not appropriate, but people watched it because it was like a box of chocolates. You didn't know what you were about to get.
Yeah, everybody watched that show.
It was something else. Anyway, back to this 4 years imprisonment, and this is going to run concurrently with this other case. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
We'll show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Are the
Yes, I did.
contents true and correct?
Yes, it did.
State's Exhibit 1 is tendered into evidence
Yes, sir.
without objection. Ted?
Yes, sir.
And it's made a part of the record. Among other things, State's Exhibit 1 states you are giving up all rights of appeal if I follow this agreement, which I am going to do.
Yes, sir.
If nothing further, I'm going to find on this case, there is sufficient evidence supporting this motion to revoke probation to grant it by a preponderance of the evidence or greater. Allegation 1 is proven true as the defendant is voluntarily, knowingly, intelligently admitted to committing the offense of operating a motor vehicle while intoxicated on or about December 11th, 2025 in Jefferson County, Texas, in violation of condition 1 of his probation order. Commit no crimes is that condition. Thus, this motion is granted. The defendant's probation is hereby revoked. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. Do you understand what has happened in this case, sir?
Yes, sir.
And does the defendant waive a formal reading of the indictment and the arraignment in 26 CR 392? Can we proceed in summary in this case?
Yes.
In summary, this indictment alleges in paragraph 1 that on or about December 11th, 2025 in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Do you understand what you're charged with there, sir?
Yes, sir.
Paragraph 2, though, goes on to allege that you have 2 prior convictions in cause number 12-13837 for a DWI, operating a motor vehicle while intoxicated, in this criminal district court of Jefferson County, Texas. And on September 11th, 2014, 1 month later, you were convicted out of County Court of Law number 3 in Jefferson County, Texas, for the offense of operating a motor vehicle while intoxicated in cause number 303751. Are those allegations true and correct that you have 2 prior DWI convictions operating motor vehicles in public places in 2014?
Yes, sir.
Are you pleading true to that allegation as alleged here in this indictment?
Yes, sir.
And are you pleading true and
Pay close
correct?
attention here, because this is the turning point of the case. The judge is making absolutely sure the defendant understands that his 2 prior DWI convictions legally transform this offense into a felony. These questions may seem repetitive, but they're essential. They protect the record and ensure the guilty plea can't easily be challenged later. Do you think this is a fair consequence for repeat offenders?
And correct of that voluntarily and because it is true,
Yes,
as it is alleged in these 2 allegations.
Yes, sir.
And do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that's enough
Yes.
to support paragraph 2 of this indictment, which enhances this operating a motor vehicle in a public place from what would be a misdemeanor to a felony offense?
Yes, sir.
Understanding that, do you insist on pleading true to allegation number 2
Yes, sir.
of the 2 prior convictions of DWIs?
Yes.
And allegation 1, is that allegation true and correct that you committed an offense of operating a motor vehicle in a public place while intoxicated on or about December 11th, 2025 in Jefferson County, Texas, after you have been convicted twice of 2 DWIs?
Yes, sir.
Paragraphs 1 and 2 constitute a 3rd-degree felony. You face no less than 2, no more than 10 years confined in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached. In your case, you would be pleading guilty here to this felony, sentenced to 4 years confined in prison to run concurrently with the preceding case. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal. You understand?
Yes, sir.
So you hear what's marked as State's Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection. It's admitted.
Yes, sir.
Among other things, this states you are mentally competent to enter your guilty plea. It's a freely and voluntarily made thing. You are doing this based upon discussions with your attorney, you were guilty of this offense and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I will follow this agreement if nothing further. I'm going to find Mr. Gilbert, you are pleading guilty in paragraph 1 and true to paragraph 2.
And that's the final ruling. For years in prison, with both cases running at the same time, this hearing wasn't just about punishment, it was also about accountability and making sure every legal step was followed correctly before the sentence was imposed. What do you think of the judge's handling of this case? Was the sentence fair, too harsh, or too lenient?